Your Honor, we have had the statements of my senior. I understand there was a decree that was issued in 2022 we are not aware of. Therefore, Your Honor, before I proceed to address the court on my side, I would wish that this being a post judgment matter, and we have been unable to find the previous advocate record, the court should grant us leave so that we can be able to face the court on record. Your Honor, this is a post judgment. So, and I understand there was another advocate. I had my senior saying, Mr. Mutai. Yes, that one we were not aware. So, Your Honor, if you are granted the same, then I'll address the court as follows. Your Honor, we were just instructed yesterday, and as we understand, Mr. Collins was arrested shortly for disobeying court summons. Your Honor, Mr. Collins has never been served with any summons. He has never been informed or notified that there are warrants of arrest against him. Your Honor, this is a children's matter, whereby Mr. Collins seems to have been ordered to pay child support. Your Honor, we are unclear of the amounts being claimed, having just been instructed yesterday night. Your Honor, unconfirmed reports indicate that the amounts are in the millions of shillings. Your Honor, our client has no source of income and would definitely not have been in contempt of court for simply being a pauper. Your Honor, his inability to pay millions of shillings is not intentional, but actual inability. Your Honor, the presence of our client in court is subsequent to a warrant, which he was never notified, never issued with a notice to show cause. Just found himself having been arrested. Your Honor, we will be making applications and pray for time to do so. Set aside all adverse orders and to review the rulings of the court in regard to the financial ability of Mr. Collins Moy. Your Honor, it is in the public domain that Mr. Collins Moy is embroiled in succession matters in regard to his father's estate, the late Jonathan Moy, and his grandfather, the late President of the Republic of Kenya, Daniel Toroitich Arap Moi, which matters are yet to be concluded, Your Honor. Your Honor, in fact, the plaintiff in this matter is also a party to those proceedings and is very much aware of Mr. Collins' financial situation. Therefore, Your Honor, our client failure to honor the decree that was issued is not because he has refused to do so. Your Honor, you can even look at my client. Where does he have those millions that is being claimed in this court?
Yes, you're on the right. I have to need to look at your client.
Yes.
Yes.
Assess
Based on
even the appearance. If you have millions, there's a way you don't come to court. Before I address on the issue of the arrest, I'll just make a statement.
Yes, Your Honor, on the issue of the instructions, I had raised that issue in the morning and this court gave directions that this being a children's matter, strict adherence to the rule of law, rather than procedure of law, wait, and directed my colleague to file his appointment, which he has done, and I'm not delivering that issue because the court already delivered itself. Your Honor, on the issue of summons, had my colleague taken some little time to familiarize with the record of the court, he would have noted that on the 26th of January 2024, my erstwhile colleague, Mr. Monyeri, had filed an application dated the 24th of January 2024, an application of content in nature, and pursuant dated the 24th of January 2024, my erstwhile colleague, Mr. Monyeri, filed an application of the nature of contempt, and this court, upon hearing that application and duly satisfying itself that the same had been served upon the predecessor counsel, Mr. Mutai Kemoi and company advocates, issued warrants of arrest against the defendants herein. The record will bear as witness that there is an affidavit of service confirming service upon the same advocates, and as such, there was no legal obligation upon the plaintiff to serve the defendant in person. Regardless, upon issuance of the warrants of arrest, the defendant was notified, and again the court's record will bear as witness that we have mentioned this matter countless number of times unsuccessfully, owing to the cat and mouse games that were played by the defendant. In fact, Your Honor, there is a report that we filed in court in our last court attendance confirming private investigations that had been done unsuccessfully upon the defendant, and requested the court to grant us an extension of time to liaise with the office of the OCS Nakuru for enforcement of the decree and orders of the courts. It is pursuant to those warrants, Your Honor, that the defendant is present in court. Now, my colleague has presented a sorry state of affairs as far as the defendant is concerned and his financial capability. However, Your Honor, I submit that there is nothing new that has been presented before these honorable courts. That information is contained in a replying affidavit that was filed before these honorable courts, sworn by the defendant on the 7th of September 2021, sworn, Your Honor, on the 7th of September 2021 in opposition to an application, a notice of motion application interim for provision of maintenance. Further, Your Honor, the proceedings of these honorable courts will bear as witness that the defendant was heard on merit. Again, he rehashed what he has mentioned to court this morning. And the predecessor courts, upon hearing the defendant and the plaintiff, arrived at a judgment that was delivered on the 2nd of June 2022. On the 2nd of June 2022. It is therefore, Your Honor, reasonably expected that upon delivery of that judgment, the defendant would have appraised the courts as to what he has done in compliance with the said judgment of the courts. Your Honor, from the submission of counsel, other than submitting on evasive grounds, there is nothing tangible that has been placed before this honorable court and or even orally submitted as to what the defendant has done in compliance with the judgment of the courts. For records purposes, the defendant was supposed to provide for education and all educational related expenses of the minors. He was to provide a medical cover for the children and was equally to share in the cost of the entertainment together with the plaintiff. Regrettably, Your Honor, there is no material that has been placed before this honorable court to show an iota of compliance. Sadly and regrettably, while he takes his responsibility casually, the minors are the ones that are getting affected. Your Honor, the firstborn child is now in Form 1 or Grade 8 at Mustard Seed School. That child, the firstborn, is Grade 8, sorry, Year 8 at Mustard Seed International School. Having completed his KCPE last year, was unable to join high school on account of lack of fees. My client reached out to the defendant to ensure placement of this child in a high school. The defendant made a promise that he would ensure the children, or rather the firstborn, was enrolled at Kabarak High School. Regrettably, that was not to be. and that minor stayed at home for 2 terms. It is only this 3rd term that my client was able to raise some funds in the best interest of this child and enroll the child in that school. Your Honor, I submit there is willful and deliberate disobedience of these court orders that were issued by these honorable courts by the defendant. I have availed the current payment receipts from Master Seed confirming the minor's enrollment this year and of this term. And thus, Your Honor, I pray, seeing that there is no proposal whatsoever that has come from the defendant that he be committed to civil jail, actually sent to jail, until such a time when he will be ready to purge the contents of these honorable courts. That's all, Your Honor. Sorry, Your Honor, I forgot to mention that my colleague alluded to a succession course that is pending at Nairobi. However, Your Honor, that is an independent court that is handling the matter. This honorable court has not been supplied with an order of stay of proceedings of this children's course, and as such, there is nothing that stops these honorable courts from dealing with this matter as it deems appropriate. Lastly, Your Honor, the decree of this honorable court having been issued 2 years ago, actually over 2 years ago, the defendant has not moved the High Court for review, sorry, has not moved the High Court for appeal, and or these honorable courts for review of the said orders. They therefore remain valid orders of the courts, enforceable, and execution, Your Honor, of decrees of court and orders of court is a lawful process. There is nothing illegal in enforcement of the orders of the court as we have done, and I therefore urge the court to rise to the occasion and commit the defendant to civil jail until such a time when he purges the contempt of court.
What I can say is this. We have just come on record. So a lot of things that have been said, we could not have known them because it's only in the morning. Actually, yesterday night at 10, I was called, given instructions to come to court. Now, even if I would have looked at the file, I need to get copies of the same, enable us to make the appropriate applications, which would not have been done given the time. Secondly, Your Honor, on the issue of the defendant being committed to civil jail, I don't know how that relates to the purpose, because even if we commit him to civil jail, how will he stay? Yes, we will stay there for 1 month, get him out. Then we come back there again. I don't know what you are saying is this. We'll be given time to put in our appropriate applications, and then my senior can serve us with the application as we make our copies so that we can know how to respond. And Your Honor, further, the mistakes of an advocate, honestly, will not be visited on an innocent critical. Tunaona pray that we look at the best interest of the children, even if we commit him. Maybe if we talk to him now that he's okay, we can see how to work it out. But if he's committed to civil jail, I don't know. Your Honor, the warrants, I believe, were for the attendance of the defendant in court, and the plaintiff is also in court represented. So I believe those warrants will now lapse. We put in our application, we respond to the application, and then if we fail, now we commit him to civil jail. That will be all,
That breaks
Your Honor, we also be filing affidavit of means because I've seen that issue has been raised.
question on the discussion by the holder on one, the validity of the secondly, on the aspect race of disobedience of that decree.
Yes, Your Honor, the issue is, that's what I'm saying, if he was aware of all this, I believe he would have reacted on time. Because you see, if you are saying Mr. Mongeri served Mr. Mutai and he never responded, then it means there's an issue.
That's all. Thereon, I'll consider the application and the response in form of submissions by parties. I'll give a substantive ruling at 4 p.m. today. As soon as that,